I'm really looking forward to this because we're delighted you could all join us, and we're here because of a very important new book that you're going to be hearing a lot about because you watch all the news shows. I know you do. I've told you to, and I know you always pay attention to what I say. They tell me that. And it's called The Constitution in Jeopardy. And it's something I very much sympathize with, and we're going to talk about the book coming up. And we have here with us an old friend of mine, well, not old, 69-ish, former U.S. Senator Russ Feingold, and he's back here at UVA. You visited with us before. We had a wonderful time the last time you were here. And he is the author, along with his co-author, Peter Prendeville, and I'll be introducing both of you separately if I can actually read the script with this, I'm old. Nobody ever thinks about, where's my flashlight? I need something. This is a book published by Public Affairs Books, and there are copies available for purchase right outside. And we will not let you go until you purchase one, at least one. Mom and Dad may want one, and Uncle John and Aunt Sue. It's a great Christmas and Hanukkah gift. Solves all your problems at once. Is that okay? All right. As I said, you're going to hear a lot about this because our democratic system is in trouble for lots of reasons. We actually saw right here, Russ, this is long after I think you were here the last time. I can't remember when you came. Yeah, when the terrible neo-Nazi rally up the lawn took place. And some of the same people, by the way, were there on January 6th. Same bunch of people, for the most part. Unfortunately, far more at the Capitol, but they make the rounds. I guess that's what they do for a living. Now, look, no Americans under 30, so that means large majority of those of you here have experienced the process of watching a successful constitutional amendment come to be, because the last one was 30 years ago, and really that was one left over from the 1790s. It hardly counts. I guess the one before that was 18-year-old vote. I remember I campaigned for that. I was very excited about that. I wasn't old enough to use it, but I was thrilled once it passed. So you haven't seen this, and it's a shame because we need to look at the Constitution in a legitimate fashion, particularly because of all of its anti-majoritarian institutions and processes. And there are things we can and must do in order to keep American democracy healthy. But even though we understand that Thomas Jefferson, and he's, we have two views of Thomas Jefferson now, so I'm going to smile for half of this and frown for the other half, and to keep everybody happy. But Thomas Jefferson said, "The earth belongs to the living and not to the dead." I remember the day he said it. We argued about that even then. Now, amending the Constitution also comes with risks, and I'm sure that Mr. Jefferson would have agreed with that had we had a chance to talk. And that's especially true for the alternate method of amending. Everybody knows the 2/3 vote of the House and the Senate, and then going to the states, and 38 have to ratify, and it's extreme. I don't think we could get that for a Mother's Day resolution anymore. That's how bad it's gotten. But the alternate method sounds better, 34 states calling a convention, national convention, to revise the Constitution, except it's incredibly dangerous, as we're learning, and as these two authors have researched and have, I think, proven in this very compelling book, the one you're going to buy as you leave. So we're going to hear from them about that. Okay, it's very dangerous for reasons that they'll explain. A lot of the planning efforts for this constitutional convention that many are talking about, they're being pushed and funded by ideologues, and these efforts have been gaining momentum. 19 states so far have passed a Convention of States resolution. And trust me, you'll know or recognize some of the names of the people pushing it, and I'm sure they'll get into that. But let me formally introduce our two guests and get them started on the discussion that they want to have. Senator Russ Feingold is the current president of the American Constitution Society. I've mentioned that he and I were grad students together. You know, we were there when the Queen was having her Jubilee. 25th. That's how old we are. 70 and death. You know, lots changed. But it was delightful at the time. And I should also introduce Dr. Christine Ferdinand, who is Russ's wife. We're so delighted to have you. And she was the librarian fellow, I believe, at Magdalen College, Oxford. So we have a lot of Oxford in the room, which is terrific. Now, Russ returned from Oxford and received his JD at Yale Law School. And then he went back to his native Wisconsin and entered politics. And he served as United States Senator from Wisconsin from 1993 to 2011. Then from 2013 to 2015, he served in the Obama administration as the United States Special Envoy to the Great Lakes region of Africa and the Democratic Republic of the Congo. During his time in the Senate, Russ co-sponsored the Bipartisan Campaign Reform Act, much better known as the McCain-Feingold bill. Some of you are a little young and you may not remember that, but people who are a bit older remember how important that was. I think it's still the only piece of campaign finance legislation that's passed in the modern era. I don't count the 70s as being in the modern era anymore. And it made a difference. And also it was bipartisan. You know, people from both parties worked on it and came up with a reasonable solution, and Russ was really the driver behind that, along with his friend and colleague, John McCain. Russ, I want to mention this too, was the only senator to vote against the initial enactment of the U.S. Patriot Act during the first vote on the legislation, and he was also well known for his opposition to the Iraq War. And boy, were you right on that one, Russ, as we all found out later on. He was, I also should add, the Senate's leading opponent of the death penalty. Russ is joined by his able co-author, Peter Prendeville, who is a non-resident fellow at the Stanford Constitutional Law Center. Peter's current research focuses on the relationship between democratic institutions, popular movements, and constitutional change. He previously was a fellow at the Senate Judiciary Committee, and this is the one I love, because at the Center for Politics, we focus on high school teachers of civics and trying to equip them and help them. And he was a high school history and civics teacher in Mississippi while you were an AmeriCorps volunteer. That's incredibly admirable, and you all should take a note. Some of you who are young, that's the time to do it when you get out of college. Now, let me quickly introduce our moderator for the day. I've known her for a long time, not as long as I've known Russ, because that went way into the last century. But Kara's much younger. Kara Ong Whaley was once my head teaching assistant before she completed her PhD at UVA, and we were fortunate enough to attract her back to UVA, where she's now the academic program officer at the Center for Politics and co-host of our new podcast, Politics is Everything, which means she can talk about anything on the podcast. You can get anybody to appear and talk about whatever they want to talk about. It's brilliant. Politics is Everything. Kara currently serves as the vice chair of the Civic Engagement section of the American Political Science Association, and her work has been featured in the Wall Street Journal, Forbes, NPR, and on and on. So I want you to not only remember the name of the book again, The Constitution in Jeopardy, but I want you to give a warm Virginia welcome to Russ, Peter, and also welcome Kara.
It's truly an honor and a privilege to join you all this afternoon. Thank you so much for the opportunity. And maybe just to highlight that we have some intergenerational relationships up here. I believe Peter was also a teaching assistant for Russ.
That's how this all came to be.
But now maybe perhaps I'm spoiling the first question. Peter, I wonder if you can just start us off by talking a little bit about how this book came about.
So Russ was teaching a course at Stanford Law School on Article 5, which was a topic that I'll let Russ discuss in more detail, but he had found a lot of interest in a previous course he was teaching on the U.S. Senate, and specifically issues regarding constitutionality and legislation. And I was fortunate to take the course my first year at Stanford Law School. I became a teaching assistant during my second year, and the book came out of our conversations about that course. And during the midst of COVID, we had some time on our hands, and that's how it came to be.
And we had to not be at Stanford, which is kind of a nice place, in the spring. Instead, he was in Woodstock, Illinois, his hometown. I was in Middleton, where I live, and we had to teach it remotely. But at the end, this brilliant student and terrific teaching assistant said to me, "You got to write a book about this." And I had just taken in this new job as the head of the American Constitution Society. I said, "Peter, I can't just do this. Let's do it together." So it was his idea, and it was it's a great example of a teacher and a student. And I don't need to tell that to Dr. Sabato, because before we go on, I just want to say, yeah, exactly. Not only is this one of the great political prognosticators in the country, I have to say that.
No, you don't.
Secondly, one of the most terrific political scientists. But what he has done here at this university is really very special. And he used to make me sing Virginia political songs on High Street in Oxford.
You wanted
when
to,
we were
Russ.
very.
You loved it.
I did enjoy it after a while. But anyway, I just wanted to say that.
Well, it's absolutely true. I don't think I know anyone who's done more for his students and for the university than Professor Sabato. So I have basically 3 lines of questioning for today, sort of past, present, and future. Your book really is timely, it's important, it's relevant, and it raises so many important questions that we as a country, as a global community, really need to be considering, especially with rising political violence, both in the United States and around the world. So one of the objectives that the framers of the Constitution were trying to do was to anticipate and overcome where the ancient republics had failed. So one of the ways through which the ancients had failed was through civil wars. And it was civil wars that destroyed the Roman Republic, and that was mostly responsible for Athens' loss for Sparta. So the framers of the Constitution understood that violence threatens a political community, it threatens the polis. And you describe in your book that they understood the need for a mechanism that would allow for what you called a bloodless revolution. I wonder if you both can set the stage for us in talking about the tensions that the framers grappled with in their attempts to accommodate both stability and continuity that Madison was a large proponent of, as well as the prospects of violence that would result from an unamendable constitution on the other hand.
Well, I'll kick it off and just saying these people were obviously products of the Enlightenment, incredibly well informed about people like Montesquieu and Locke and some of the theories about how government should work, and it led to them actually attempting something that had essentially never been attempted, which was a written constitution. The other thing, though, was the violence and the possibility of violence wasn't some kind of a theoretical thing for them. The blood was laying around them. They had just been through a very rough thing with their former mother country. And the question was, is there a way, for the first time basically in human history, to create a mechanism in a written constitution where you could actually amend the Constitution without bloodshed? And so this is where the idea of a bloodless revolution comes from. Clearly the founders considered this to be one of the most important provisions in the Constitution, and we liberally cite George Washington and Madison and others specifically saying that they don't think their generation knew it all or would know it all, that you had to be able to amend the Constitution. Peter?
We start the book, again, as you mentioned, the first chapter is called Bloodless Revolution, and we start the book actually during the Revolutionary War, and that was a very distinct decision, not starting, as many books about the Constitution do, starting with the Convention of 1787. And we look at how citizens during the Revolutionary War, making state constitutions, were grappling with this question about how is it that a community that believes in the importance of fundamental law to constitute a polis, how do we actually make that real? And if we desire to change the nature of the political order, how can we do it without having to resort to the bloodshed that was, as Russ said, laying all around? And so there were false starts and interesting debates, because it really was a novel question. The state constitutional amendment provisions, and then Article 5, which is the amendment provision in the federal constitution, which would be drafted a decade hence, really were the first attempts in world history to draft constitutional amendment mechanisms not premised on unanimity, at least for a federal constitution, in regards to the 1787 convention. And so it really was a remarkable time.
I wonder if you can remind us, what are the two mechanisms in Article 5 of the Constitution?
So amendments need to be both proposed and then ratified. Article 5 provides that amendments can be proposed in one of two ways. The first is by Congress. If 2/3 of each House of Congress propose an amendment, it then is sent to the people of the states for ratification. And then there's a second proposal mechanism, which is the focus of the book, which is a convention convened under Article 5. Once the amendments are proposed to the states, they then need to be ratified by the people of the states in 3/4 of the states.
So I wonder if you can talk a little bit, and you go into detail in the book, so buy the book so you can really understand the debates of the time. But I wonder if you can talk a little bit about how they arrived on these two provisions, because these are very different mechanisms. One is a very top-down approach, and another is a bottom-up approach. So how did we get to that point?
Well, we studied this pretty closely because we believe a lot of the understanding about Article 5 is flawed. A lot of people think that, really the main idea here was that Congress would do it, and that it was sort of a throwaway to throw in a Constitutional Convention. That does not reflect the proceedings at the Constitutional Convention at all. The convention began with a certain state proposing something. That would be this state, the Virginia plan. And in the Virginia plan, there was, of course, a provision to allow amendments, but it had nothing to do with Congress. In fact, it explicitly said that the national legislature would not be part of it. So, the plan was put on the table, and the Committee on Detail was created. And over that hot summer, the Committee on Detail came back with a proposal that, again, did not involve Congress passing constitutional amendments. It said that Congress would call the convention, but it was only by route for leading toward a constitutional convention. And so it comes out this way. But a certain gentleman named Alexander Hamilton said, no way. He said that the only way to have good constitutional amendments is have the national legislature to do it, because they're the only ones that are going to understand the whole of what our country needs, and the states would move things backward. And he persuaded, I think it was a 9-1, he persuaded them to knock out completely the idea of a constitutional convention. And that's where it was heading until George Mason and a few others basically said, you do that and we're out of here. And so they cut a deal. And the deal was to add back a provision that would allow a constitutional convention by 2/3 of the states applying. And Congress is not given any discretion. We just stress this in the book. The rules for the congressional amendments are clear as a bell. It's limited to whatever they say. It's 2/3, 3/4. There is nothing to tell us basically how this convention is supposed to work. So finally they just quietly agreed to this. And I think we both agree, although we have great reverence for the Constitution, that it was probably not done very well. It was somewhat like the Electoral College. And that's why we're kind of in this mess right now.
Professor go ahead.
To the point of it not being done very well, there were comments, James Madison in his notes remarks that contemporaneously that the convention mechanism was flawed, added at the last minute as it was flawed because there weren't sufficient, what he called constitutional regulations as to quorum and form and the like. And so it's clear that this was a last minute compromise. And that it inserted an inherent tension into the Constitution by endorsing two different theories of constitutional change, both from the top down, but also from the bottom up as a means to check the regime. And it's a tension that we've really never come to terms with as a country and as a core part of our thesis.
I'd say to Professor Sabato that I feel comfortable criticizing a provision of the Constitution here because Mr. Jefferson wasn't there.
Yeah,
He was in France.
He was in France,
So-
but he had
so-
views on it. He had views on it.
Well, Peter has also presaged my next question, so thank you. But I also want to bring Professor Sabato in on this as well because, as you all know and have read, he wrote a book about Article 5 as a mechanism. Well, it's about making, as the founders themselves recognized, the Constitution itself wasn't perfect. You cited George Washington, after the convening of the convention, said, it's not perfect, but we've ensured that there's a mechanism to make it better. And Professor Sabato has a book that was written 15 years ago called A More Perfect Constitution, and you thought of this idea of using Article 5. So what was your thinking in terms of ensuring a greater legitimacy of the Constitution by using this process for amendments and going through the states?
Well, I wrote it in 2005, 2006. It was published in 2007, and so it predates lots of things that have happened since that have made our politics more difficult and made compromise more difficult. It made it almost impossible, I think, for people to come together about basic things. So, I proposed 23 changes to the Constitution. I'm shocked that not one of them has been passed and ratified. It's an outrage. It really is. But that's the truth. Now, I tell you what their book did for me. It clarified the fact that what may have once been a more innocent opportunity for change has become a very dangerous potential precipice for the whole country. There are a lot of things that could produce fracture in the United States, permanent fracture. But that would be one of them because, as Russ just mentioned, there's no limitation on what will actually happen at that convention. And this connects to so many other examples in the Constitution. I'm not criticizing it. They were under pressure and they had to deliver something relatively, well, more or less quickly, at least for that age. But at the Supreme Court, it would have been nice if they had allocated once the original court members were appointed, it would have been nice if every president got 2 appointments. Just to give one example, the Electoral College is a nightmare. Don't need to go into that. It was particularly awful as they originally set it up, and on and on. There's so many pieces that maybe made sense for the 1790s, but certainly don't make sense today. But you have to measure the opportunity for positive change there and compare it to the potential disaster that could happen if we actually had a convention. And I'd prefer to delay it to a more quiescent period in American life if there ever is one. It'll be up to the young people in this room.
Yeah. So I want to lean into, Russ, you mentioned the bargain that was struck around Article 5, and I want to lean into this question because you also outlined the ways in which, in your book, the ways in which the Constitution defined who is part of the political community and who is circumscribed from it. I wonder if you can talk a little bit more about the specific ways in which the odious bargain, as you call it in your book, privileged the states and the political elites of the South to perpetuate enslavement and protected them. So Article 5 protected them in many ways until at least 1808.
Yeah, one of the interesting things about our Constitution, if you read it, is it is not, when there's an amendment, they don't strike out language and replace it. So everything's in here. 3/5 man, horrific provisions are in here. And if you read Article 5, you'll notice that there are basically 2 things, maybe 3, that can't be amended. One of them expired. It's called Keeping the Fugitive Slave Law till 1809. It was a 20-year extension of the Fugitive Slave Law, which of course had to do with protecting the slavery interests of the South. And the other provision, which actually has this impact as well, is there's only one thing you can't change in the Constitution. Just one thing. Equal representation in the Senate. You can get rid of the president. You can get rid of the Supreme Court. You can do whatever you want, except every state gets 2 senators. Or it could be 1. It has to be equal. And so that is, in theory, unamendable, although there's some debate about it. But you see, that's all related to protecting this. And the great compromises, as we know, at the Constitutional Convention, all had to do with the fear of particularly the slave states, that somehow the other states would get together. One reason they wanted the convention was the fear that somehow three quarters of the states, that 2/3 of the House and the Senate would vote for an amendment that would eliminate slavery, and somehow they would get 3/4 of the states to approve that. So yes, this is a tragic aspect of our original document that was significantly addressed in the first great wave of constitutional amendments after the Bill of Rights, which was Reconstruction. But yes, this is the Constitution was significantly about that. It would not have been approved or ratified had it not been for those concessions, almost certainly from an historical point of view.
Peter, you already started to speak to this, but I want to follow up. In reading your book, Article 5 embodies this, I think, really underappreciated tension in the Constitution. It's both reflected in the constitutional debates, but also embedded within the Constitution itself between institutionalist theories of democracy and governance and a more radical grassroots theories of resistance and change. I wonder if you can talk a little bit more about how Article 5 embodies that tension, and then how you see that continuing to play out today. I'm thinking even specifically as we see the word democracy becoming politicized and parties removing the term and replacing it in their state platforms.
Well, it's fascinating and striking to think about how the debates of what at that point would have been the burgeoning groups we now would call Federalists and Anti-Federalists are still so much alive today. And Article 5 in many ways is the centerpiece of that. Russ mentioned before the debates between Hamilton and Mason, Hamilton being the standard bearer for the Federalist position. Hamilton envisioned a federal regime that is in the book, we say the Constitution would erect a tall rampart around the federal government and that it would be able to fend off assaults. Mason feared, and his Anti-Federalists feared a strong central government and worked diligently at the convention to create mechanisms by which abuses could be addressed by the people. It's interesting, Mason famously remarked after the convention adjourned that he wouldn't support the Constitution and that he would rather chop off his hand than sign the final document. And so, although the Anti-Federalists worked diligently to oppose ratification, their handiwork still remains. And so we see to this day these two theories of federal power leading to national unity and the advance of policy priorities, and this more bottom-up checking nature to Article 5. I'd also say that we've seen this throughout history. If you look at the Progressive Era, for example, although we think of the Progressive Era amendments as being proposed by Congress and ratified by the states using the normal mechanism, in fact, when you actually look at history intently, you realize that we got very close to a successful convention call at the turn of the century. And in many ways, it was this successive round of applications for a convention, starting with Nebraska in, I believe, 1895, that really awakened Article 5 at a time when leading scholars, including Woodrow Wilson, who was a political scientist at Princeton at the time, future president, remarked in his magnum opus, his major academic work, that he thought Article 5 was dead. And
The Constitution would never be changed.
Yeah, and 2 decades later, he sits as president when the pioneering Progressive Era amendments are ratified.
Direct election of senators, the income tax, women's right to vote, and yes, prohibition.
And so this you can see this what we call in the book a tension of Article 5 endorses both a federalist understanding of constitutionalism and constitutional change, and also an anti-federalist vision. And this is a tension that is very much alive with us today.
So we've already started to discuss, and you referenced freely George Washington. He said, quote, "not free from imperfections, but as a constitutional door is opened for future amendments and alterations." So what Article 5 did is it left an acknowledgement that the American experiment was a work in progress. So I wonder if you can talk about this other dual jeopardy, as you call it, to the Constitution, about ossification and stagnancy. So we've had these periods that coincide with hyperpartisanship and polarization in the past, where there have been moments of progress, but we also have long periods of stagnation, which we seem to be in now. I wonder if you can talk a little bit about this other profound state of jeopardy that the Constitution is in, and perhaps the ways in which the Constitution, do you think that these movements for a constitutional convention now reflect a crisis of legitimacy for the Constitution?
Well, I think they do, and I think that's why we were very careful in this book. We were putting out two warnings. You know, one warning is about the possibility of right-wing capture of the Constitution and gutting it. The other is that the Constitution cannot be changeless. And this is what Dr. Sabato wrote his book about. He just explained that he proposed, I read it, there were perfectly reasonable proposals, and now it's almost impossible, partly because it's very hard to do. We just simply have the hardest Constitution in the world to amend, period. But if you put on top of that horrible partisanship, nothing can be fixed. And the right to vote's being gutted by the Supreme Court. There's no right to vote in the Constitution. The Electoral College is still there. We don't have anything in our Constitution about protecting the environment or climate change. These are things that maybe should be considered by reasonable, rational people to update our Constitution. But the system is set up in a way that has essentially blocked this idea. We actually call it sort of the archaics, where people just think, well, that's really never going to happen again. And so what do? And I'll let Peter say more about this. We basically obsess about the Supreme Court. Supreme Court is the locus of power in this country now, not the people. And the Constitution begins with the words, "we the people." So if you could say more about that.
Sure. I mean, both jeopardies are grounded in again, this notion of bloodless revolution. What was it that this founding generation saw as, what did it mean to live in an American democracy, and what did it mean for this new, quite novel theory of American constitutionalism? And a key tenet of that new theory was that the people constitute their government, and the people are empowered to change that government, and in the case of amendment, through these settled procedures. And we argue in the book that over the last probably half century, that notion has been changing. We've been losing sight of this revolutionary ideal, and that we should be crafting a constitutional politics that allows the people to be debating constitutional matters as a first-order inquiry, rather than obsessing about these second-order questions about differing modes of constitutional interpretation, the mechanisms of judicial elaboration of constitutional meaning, and that we should have a flowering of American debate about our fundamental law. And that debate can only happen through Article 5. It happens through both a culture of constitutionalism, but also a process, and a process that is workable and that is fundamentally popular in nature, that gives new life to the invocation of the Constitution, "we the people."
Yeah, you can think of Article 5 as a healing mechanism, a release valve. It doesn't work in this environment.
You also write in the book about how the bulk of amendments, and almost all of them, have made the federal Constitution the dominant repository for civil rights, and the federal courts as the place that adjudicates those rights. Can you talk a little bit about what animates the movement you study in the book, and their use of Article 5 and its provisions to deconstruct federal power and to roll back rights?
Well, as Peter, of course, pointed out, the very origins of our country and Mason and the anti-federalists, many of the people in this state did not buy into this idea of a strong federal government. So it's not as if this is some completely new thing. On the other hand, after the Reconstruction Amendments, after the battles against Jim Crow, after Brown versus Board and all the advances from our viewpoint that were made, there was resistance. There was particular resentment to the Supreme Court rulings that some believe was one of the most important. And Baker versus Carr and Reynolds versus Sims would said that when you're in your state legislatures, it has to be one person, one vote. It can't be, 22 state senators, and one of them represents 50,000 people, and some of them represent 10,000. So this was a major decision, and it triggered the first sort of, if you will, modern, if we can include our lifetime as modern,
Sure.
Movements led by a guy from his state. I tease him about this a little bit. Everett McKinley Dirksen, great senator, Republican senator, who helped make sure we got the civil rights law. But he was part of this effort to stop reapportionment, and he tried to get it through Congress through a constitutional amendment. Was not able to do it. So they kicked off the desire to have constitutional convention to do this. And this goes back to your original question about preserving the rights of certain parts of the country. So they started really moving on this thing. I think they were within one or two states, right, Peter, of getting the constitutional.
Wisconsin was the definitive vote, yeah.
So I
started it, he ended it.
Dirksen suddenly dies. And my state, that hasn't been doing very good things lately, but a lot of times, stops it. But that's how close it came. And so this is a movement that then transformed itself, one would argue, based on something you may or may know about. In the 70s in California, there was something called Proposition 13. A guy named Howard Jarvis used the direct democracy mechanisms that they have in that state, but not in my state, to pass a severe limitation on the use of the property tax. So people at the national level started saying, wait a minute, we should have a balanced budget amendment. We have to balance our budget at home. Why shouldn't there be a balanced budget amendment at the federal level? I mean, it's not an irrational argument, but it was very popular in conservative circles, and it passed many states. I think we see this as part of a string. And what then put it into overdrive was the election of a certain Barack Obama, who became president, which of course I was very happy about, but a lot of people were very unhappy about it. And they saw, even before the man was sworn in, they said he's a socialist, and he's going to do this, and he's going to do that, and all of a sudden there was a torrent of applications for conventions, right?
Right. And so this movement really took root in the mid-2000s and has been gaining steam ever since. But it really does find its roots in the Dirksen era. And the reaction to the liberalizing role of the Warren Court, which, paved the way for many of the civil rights advances in the 60s. And so it's part of this story about this effort to use the amendment mechanism to check these expanses.
Just a little follow-up on that, and that the Dirksen effort was very interesting, and he was an interesting guy, and unfortunately he did die. I think had he remained in office, a lot of better things would have happened. He died, I think, in 1970 or somewhere in that vicinity.
Late 60s, I think.
Late 60s, something like that. And given the norms, the political norms of the time, let's suppose they had succeeded with a convention, with Dirksen as the godfather of this to some degree. Would a convention have been more limited? Would it have been able to stick to one or two or three things as opposed to what is likely to happen today, becoming a runaway convention, dealing with anything and everything?
That would be my guess. First of all, a number of historians believe that Dirksen didn't really want this thing.
Oh.
That he felt that he had, because he was part of the cause, that he had to do it. But
You're saying he was a politician?
No, yeah, kind of. Yeah, okay. Senators from Wisconsin are purely principled, but
Of course.
not really. But I'm guessing there was not this sort of, frankly, crazy right movement. You did have your John Birchers and some of these people, but that wasn't the tenor of these individuals. No, they didn't like the reapportionment thing. Yes, they wanted to create something called the Court of the States, which would have allowed a court to overrule rulings of the Supreme Court. But there wasn't this sort of social issue, anti-democratic stuff. So I'm guessing it would not have been the end of the world. I remember I grew up listening to Illinois media. So they were always talking about a constitutional convention there. They had a big con was like this thing at the state level. So I think there would have been a limited, but they were worried. We have in the book Robert Kennedy warning about this. William Proxmire questioning Dirksen, making him answer questions about, can this thing be limited? He actually admitted that it couldn't be limited.
And this is key, I think. We could debate the role of Dirksen and kind of as leading the movement, but what is clear from the historical record is that Dirksen did not subscribe to the view that the convention could be legally limited. And there is this fascinating debate that we include in the book that between Senator Proxmire and Senator Dirksen, where Dirksen says quite emphatically that when the convention meets, it's the people's business, and there's no way that Congress or state legislatures through applications could limit that. And so even then we're seeing the kind of contours of the debate that is with us today.
The Runaway Convention is the term that's often used, and one of the most famous constitutional law professors in the 20th century was Charles Black. And he said, what do you mean runaway convention? There's nothing to run away from. I mean, it's just open.
Yeah.
Well, there is you talk about the great deal of uncertainty around the Constitutional Convention and who would have the power to select delegates and how much power each state would have at such a convention. I wonder if you can talk just a little bit more about where the different legal theories are manifesting on the sides, especially of this current movement.
Well, I think it's, as with all constitutional questions, it's important to start with the text. What does the Constitution actually say? Article 5, if you read it, it's quite short. You can see it at the beginning of the book. It's silent as to these questions. And as we said before, this is a reality James Madison noted even shortly after the convention adjourned, that there weren't these sufficient constitutional regulations. Over the centuries, there has been some consensus. That consensus now is being challenged quite rigorously on the right. But generally speaking, we don't know how delegates would be selected. Those on the right now claim that state legislatures would be able to appoint them because, in their view, Article 5 conceives of a convention not of the people, but a convention of the states. They have adopted a quite Articles of Confederation notion to Article 5 that supposes that the states constituted the federal regime, and thus it is up to the states as sovereign entities to amend that regime. We would point you to the first line of the Constitution that says, "We the people." To counter that theory, the Articles of Confederation was much more blunt about from whence its power came. It says, "We the delegates of the states." So that's one theory, that state legislatures would appoint the delegates. The alternative theory is that that there should be a popular election, as there are in many states that have held state-level constitutional conventions. Illinois being a good example, Montana being another in recent memory. And then there are we could go on the myriad list of unanswered questions. I think the most important one is how would the convention actually vote? Contemporary activists claim that the convention would adopt its rules and adopt proposed amendments by a simple majority vote along state lines, meaning that Wyoming would have the same exact vote as California. So we're talking extreme malapportionment. That is not a settled matter of law. And it's quite possible to imagine another scenario, something based on proportional representation or the like. But I think the key element is that we don't know. And it is quite a vast void. And one of our deepest concerns is, were this convening to be triggered, there really are no mechanisms to resolve these uncertainties. It's quite possible the courts wouldn't get involved. We argue they shouldn't get involved. It's really outside their power. And so that's why we end the book where we do, saying we need to reform this. We need answers to these questions, and we can't allow these uncertainties to continue. It's too dangerous.
And I don't want you to leave without understanding what's going on in this void that Peter just so perfectly described. So there's these two theories. But the far right is acting on the first theory, and they're answering all these questions. So I refer you, if I'm allowed to read a passage,
Please.
from a chapter entitled What Trump and the Tea Party Couldn't Do. And there's a quote from a guy I used to serve with in the Senate you may have heard of, Rick Santorum, who's working for these people. He says, we're planning on putting in place to get us to the place where the safety's off and we have a live weapon in our hands. And we describe in this chapter, and if the other stuff seems too sort of constitutional law-ish for you guys, just read this and you'll say, uh-oh. Because, of course, they gathered in Virginia, in Williamsburg, and they had a mock convention. And yeah, they had a guy show up at the beginning dressed up like George Washington, and they all told each other, you're gonna be like the founding people in our country. But they weren't goofing around. They weren't playing. They were very, very effective at doing this. We write, even to a casual observer, the debate would have been impressive. Delegates, the vast majority of whom were conservative Republicans aligned with the Tea Party movement, approached the affair seriously and engaged in good faith debate. Working committees parsed amendment text, weighed the legal meaning of certain terms and phrases, and hashed out draft proposals. When the proposals were brought to the floor, objections were raised and compromise reached. And then, as Peter just pointed out, they answered the question about how would the voting be done. Meeting in state delegations to deliberate amongst themselves, delegates ended the meeting by rendering the state's single vote on each proposal. And in so doing, the dramatic reading of the roll call caused those present to celebrate the element of the convention process most essential to their plan to radically transform American fundamental law. It's malapportionment. It is the Electoral College on steroids. One vote per state, not we the people. So they're way ahead. They're already training state legislators who they will name if this happens. I know who they are in Wisconsin. They are not my favorite politicians. They are the ones who would be over there writing your Constitution. So this is really a scary thing. Yeah.
Russ and Peter, tell the audience, please, who's funding this and how it's being organized.
Well, it's kind of a who's who array of frequent funders of right causes. The Koch brothers are involved. The Mercer family is involved. And it's important to note that this is a very advanced, sophisticated operation. It's quite remarkable. They have, state captains in every single state legislative district. They're actively engaging state legislative leaders. It's a very sophisticated operation. And so that's why we think it's so important for people to be involved in this and to note what's coming down the pike, because these uncertainties, a right answer is being written about these questions. It's being put in publications by groups like the American Legislative Exchange Council, ALEC, and it's being put to state legislators as settled legal fact. And we go through some of these publications in the book. It's quite shocking, the manner in which these documents are written. They speak as if these issues are completely settled, that there's no debate. And some of the answers are, I don't understand how they have legal basis, and even debatable legal basis. And so it's really quite troubling, and I think people need to think about this and need to be engaging in serious debate and discussion about this fundamental constitutional mechanism.
My wife, Christine, and my brother-in-law were intrepid enough to go down to Wisconsin State Capitol and attend one of these gatherings. And it was
Undercover?
Yeah, of course. I mean, I couldn't go down there.
Not quite undercover. We were the only ones wearing masks.
And this
you were
This is over a year.
So literally, but not figuratively
time ago.
undercover.
So she, Meckler was there, Santorum was there, this thing, and there were perfectly earnest people checking people in, the way Christine reported it. So, yeah.
And they're also presenting workshops at gatherings of state legislators as well.
yes, the
so I
ALEC,
think there was one in Arizona just a few weeks ago.
Right,
that's
and so
right.
they do pre-conference workshops as we would at an academic conference. And so they present it just as Peter described,
We
as
note that-
we're going to train you how to do this to present it.
Right, and we note in the prologue a very fascinating occurrence in Montana, a state that you think would be quite behind one of these efforts. An application effort failed, in part because of the efforts of the John Birch Society, which is quite conservative, but they share concerns about this.
They're worried about what might happen at a convention.
Right, it's interesting because a conservative state senator remarked about how this went down in the Montana State House, and it involved a meeting, and her phrase was "whining and dining" of state legislators that occurred outside public view before a committee had taken up the application itself, and so. Like I said before, there are right answers to the myriad array of questions that there are no answers, but there are answers just being divined from thin air. And it's problematic in many ways, but principally because, as we say, there's really no mechanism to resolve these questions with certainty. If the courts don't get involved, and if a convention is left to its own devices to answer the questions, without even the most basic assessment of how do you vote, how do you resolve it?
Yeah, and let's not forget the composition of the current Supreme Court. Just for the younger people, the John Birch Society spent the 1950s trying to convince people that Dwight Eisenhower, the Supreme Allied Commander in World War II, was a communist. That was their number one objective throughout the 1950s. The Republicans isolated them. They were considered so extreme they didn't even want to have them in their midst. Well, things have changed. We've got a lot of successors to the John Birch Society, and they're right at the heart of American politics. You
They
mentioned
kicked them
Allen.
out of Wisconsin. They
Did
kicked them
you?
out of Orange County during Birch Society.
Yes.
So where did they move? Appleton, Wisconsin.
Appleton,
the
Wisconsin.
birthplace of Joe McCarthy.
Well, that was your area. You should have done something about it.
Anyway, sorry. Is there a question there?
Well, no. I was going to say about Allen. See, they have organized and been extremely well funded for years and years and years. And as Russ knows well, the Democrats did almost nothing for years and years. They're finally starting to organize for state legislative elections and to use a similar mechanism. But they're decades, really, not just years,
Absolutely.
but decades behind.
No, mea culpa. I was a state senator, and I go, well, why are these Republicans running for city council and school board? And, that's not where the power is. And sure enough, they were doing what we called, maybe you guys do, farm team.
Yes.
And, these people may have started on, the town board in Lodi, Wisconsin, but now some of them are congressmen and senators, and so the right had the long view.
The left for the left for so long has looked to the federal government, and I think
exactly
there was
right.
a statistic from around the time of President Obama's election, that there was something like 50,000 people who wanted to run in state and local elections, but because it was all funneled through his campaign and not through the national party, it was a lost opportunity, right, for the Democrats. And so there has not been that considerable thinking on the left side about how to organize at the local level until perhaps 2016, I think they started to take it a little bit more seriously.
Exactly.
Russ,
go ahead.
Russ mentioned before, but we talk in the book about this phenomenon called the archaics. And it's this idea that's quite common on the left. I would say it finds devotees across the ideological spectrum, but it's quite common on the left, of just thinking that some things don't really matter that much, that questions are not important, and it's quite common with constitutional provisions. Things that they're not worth our time. They'll never be a problem. We talk in the book about how this was a common view of the Second Amendment from the 1970s up to the 2010s. People said, oh, the Second Amendment's not that big of a deal. And it's quite common on the left, and we argue that Article 5 is just another one of these supposedly archaic things that we can ignore it, it's not that big of a problem.
I mean, in fairness, we're trying to say to people, this isn't January 6th. This is legal. What they're trying to do is completely legal. You can't sort of tar them with this idea that they're, undercutting our democracy by doing something that the founders said go ahead and do it. So that's part of the reason we're warning people.
So we want to open up to an audience Q&A, but I do also, as we do that, I want to ask you, there is actually near universal agreement that our political system is not working well across a broad range of surveys, and public support is actually quite high for fundamental change to make our political system work better. Of course, the challenge is that there's both substantive and significant disagreement about what that direction of change should be. What do you imagine as a path forward for the Constitution and for the legitimacy of democracy and self-governance, especially with the concerns about ossification and stagnation that you describe in the book?
Start with Article 5, what to do about
That's part 4.
Go ahead.
So this is part 4 of the book. It's why we ended the book where we did. We need to rekindle, like I said at the beginning, a new constitutional politics. You're right. I think people are feeling for the first time, or in recent memory perhaps, almost a visceral belief that we need change, fundamental change. And that's the exact same idea that the founding generation had. How do we actually provide for this kind of change? We shouldn't need to resort to violence. We should have these settled means for a sovereign people to reform the constitutional order. And the way to do that is through Article 5. It's through procedures that can channel debate toward the high ideals of constitutional reform, and that we can pursue that reform in a manner that is popular and democratic, that gives it gives an animating reality to the notion that we the people constitute the government, and also through a procedure that's settled, that we can actually have a procedure that people agree on, such that we can have the substantive debate that's necessary, rather than being concerned about all of these secondary questions about how things can go wrong.
And to sort of take that to the broader question, that the predicate for that to happen is that this political culture has to change. I want you to know, because I was a legislator for 28 years, members of Congress don't want to behave like this. They're responding, some of them do now,
Yeah,
but the people, some do. But the ones that I serve with and others who sort of felt they had to veer to the right, it's because their constituents started demanding that they not work with the other party. When I was a 29-year-old kid running for the state senate in a rural district with a ton of hair, I was about 110 pounds, I'd come to a door and I'd go, hi, I'm Russ Feingold, I'm running for the state senate. And if I said anything about Democrat or Republican, they'd close the door. They'd say, we don't want to hear that, we want to hear your ideas. Well, that changed in 2008, 2009. And they started threatening, particularly on the Republican side, anybody that would work with the other side. So it used to be the greatest thing in the world. I used to be able to go to town meetings and just say, hi, I'm here, I'm doing a bill with John McCain. Yay, Republican county. I liked it. I liked it a lot. Because they just wanted you to work together. Well, somehow this society has to decide that it's a community again. And if that doesn't happen, none of these other things can happen. Politicians have to be rewarded for working with the other side. And I'm going to say this again, I get in trouble with my liberal friends. Liz Cheney. What she did was heroic. Now, I don't think she's that big of a right-winger as people think. She was representing Wyoming. And they threw her out. When she runs for president, there's going to be a lot of people that are going to vote for her because of her singular act of courage. Because that was in the spirit of us all being a nation and the rule of law. I mean, I'd never vote for her, I'm sure, because of my views on issues. But the country, I hope, gets an appetite to have somebody with that kind of courage and integrity to do something like that. And it wasn't easy. She gave up her seat.
And her leadership position.
What's that? And her
She
leadership
gave up her
position.
leadership post.
That's a profile in courage. Well, she's already gotten a profile in courage award for that. But I mean, this is what the country needs, is people who will do things like that.
Russ, I'm going to shock you. You know, because I don't agree with Liz
We've done it
Cheney about
before.
loads of issues, okay? But for precisely the reason you've just identified, well, first I nominated her for the JFK Profile and Courage Award, and I was delighted she won it. And second, on that very day, I gave her the max, $2,900 for a primary race. And people who've known me through the years may have just fainted. But, you know, I gave $2,900 to Liz Cheney, but it was precisely for the reason that Russ has just outlined. And if we don't start doing things like that again, I think we're headed for a split up. I really do, as a country. I don't see how we survive the direction in which we're moving. Do you agree with that or not?
Oh, absolutely. Well, part of the problem is our age, the 70-year-old, you know, we grew up believing certain things could never happen. Those, you know, just guardrails, we call them democratic guardrails. We believed that those really were serious. And everything suggests that those guardrails are gone. Anyway.
We'd like to open it up to questions from the audience.
Somebody in there.
Cameron?
Tell them who you are and so on.
My name is Cameron Colstead. I am a fourth-year major in history and foreign affairs. I'm from Stafford, Virginia, and Lisa and I tend to follow politics very closely. I guess that's one of the reasons why I'm wondering. So which states have currently filed for constitutional conventions, and which ones are likely to file for constitutional convention?
Which states?
Yeah.
Well, we have a record of which ones have already applied, and you know, obviously there are more obvious ones. States like Wyoming and Montana have applied, but my state is so violently malapportioned. In other words, we have a Democratic governor, a Democratic lieutenant governor, a Democratic attorney general, but our legislature is far-right malapportioned, and they pass these things 5 minutes after they have the chance. They've passed all of them, I think. So it's not just, this is what people say, well, you know, you need 34 states, you need 38 to ratify. It includes states like Wisconsin.
Right, and there's just, and we discussed this, we have a whole chapter on it, but there are many issues about the nature of these applications themselves as legal instruments and how one does the counting. So it actually could be quite challenging to say how many, you know, the question everybody asks, well, how many states away are we? It's actually can be quite challenging to determine that. As Russ said, there are different groups that are pursuing the same, pursuing a convention, but they have different aims. Because a convention can't be limited, you really need to look at them all as a monolithic whole, because once the convention is convened, claims of limitation are irrelevant.
Can you just follow up, yeah.
But I guess generally most organized efforts are on the right, so I'm guessing
Right.
So I'm guessing primarily if the Constitutional Convention be held, it would be basically done to advance the aims of those on the far right.
That's our concern.
And we should say there are liberal groups that are pursuing this as well. They haven't had nearly as much success, but there are some. Again, on the theory that the convention could be limited, but that has no legal basis.
They really want to overturn a decision I can't stand, Citizens United. They want to have a constitutional amendment on campaign finance reform. And they have organized and did get some states to pass applications, but it's tiny compared to the right.
And it's interesting, for example, some states have actually, I think it was Massachusetts, asked voters, should we consider this for campaign finance issues? And Massachusetts formed a state commission to analyze the question. I believe, I would need to check this, I believe the result was they said, no, don't do it, because it's too dangerous, because of these issues about limitation. So it's not unique to the right, but it's dominated very much so by the right.
Yes.
Yeah, sorry about that. I'm Jeremy. First off, Senator Feingold, my parents are huge fans.
Wisconsin people?
Oh, no, Virginia people.
Okay, that's good.
It's like you're a little bit of a ways off. You know, right now politics kind of feels like there are like 30 different five alarm fires going on at the same time. So I guess my question would be, why should I don't know if anyone else feels this way, why should I care about this more than other things? Because it kind of feels like, I mean, maybe it lines up, you know, pretty well with other issues, but like when I'm thinking about who I want to give money to or work for,
Right.
or vote for, like, why shouldn't the primary concern just be like, holy shit, Doug Mastriano is such a great guy, rather than like, he wants to call kind of the new constitutional convention?
Well, I mean, I think it's a fair question. And the reaction we got, you know, from some of the great scholars in the country was, oh my God, not another thing. You know, but, you know, what you want to do is understand the range of things they're trying to do. We're not suggesting you should drop your other concerns, but you're talking about some short-term electoral concerns. This is a long-term concern about the protection of the Constitution. And they are planning to do this. I don't believe they're just doing this to put pressure on Congress. They want to rewrite the Constitution. And so, no, our desire is to get this on the horrible list. And here's the other thing I'm convinced of. They'll do anything. They've made it very clear they'll do anything. And so for us to not understand the range of what they're trying to do and to discount certain things, I think it's a mistake. We just want people to know about it at this point.
And they're counting on Democrats and liberals never to get a clue until it's fixed. It's in, the fix is in. That's what they're counting on, because they want Democrats to be focused on Mastriano and that crazy from Arizona, Blake Masters, and some other people like that. It takes all the energy out of their ability to get things done politically. You have to be able to operate at lots of different levels for lots of different reasons simultaneously if you're going to win in the long run.
Two things. One, watch the money. This is a movement that's very well funded, and that means that people think it's worthwhile. And I think that's reason alone to be concerned. Two, history makes clear that you need to think of constitutional amendment and constitutional change in the timeline of generations. It's not about the next electoral cycle. Great example, the most recent amendment to the Constitution was proposed with the original Bill of Rights in 1789, and it was ratified in 1992. I mean, talk about a time span. And there's no reason to think that amendments proposed by a convention convened under Article 5 could live that long as well. And so you need to think of it in that kind of sense. I don't think political concern is a zero-sum game. I'm not trying to aim for 5% of your time. I think it's more just add it to the list. It's something to be concerned about, and think of this as a slow burn issue.
I think the distraction point is really important. Just to read a fun quote about how these people doing this think of this. They think of this as the big one. Some Ohio Senate Majority Matt Huffman said, "This concept of an Article 5 convention is almost like a Lord of the Rings movie where some ancient giant beast or some sort of secret is unlocked, and suddenly it's the greatest power, but nobody knows about it, or it was lost for a long time." So they have kind of this.
That was said at an ALEC gathering. So that gives you an idea of how it's being conceived of with state legislators.
Jim Nix, on the electoral board in Charlottesville, I'm the Democratic chair here for 4 years.
Long-serving and long-suffering.
Something in retirement. My career was as an intelligence analyst, so I'm very alarmed by some things I'm reading in the paper these days. But I have a question about the states that have passed resolutions calling for a constitutional convention. Some of these happened some years ago, and are all those still valid, or can states revisit that decision? I mean, how many are currently committed?
So this gets
We
back.
spend more time on this than anybody would want.
This gets back to the question. It's such an important yet vexing topic that it actually, again, is a chapter. It has its own chapter.
I haven't bought the book yet, but I'm going to correct that oversight at the end.
The answer to your question is yes. By our count, it's complicated. You know, there could be applications that are actually just sitting in state archives somewhere. They never were transmitted to Congress. But by a conservative count, there's over 400 applications that have been submitted since 1789. Some states believe that they can rescind these applications. Some people argue they can't, or that rescissions have to meet certain very strict codes.
It's never been decided, though, right?
No, and it's just added to the list of all the unanswered questions that, in the void of which can come new theories about, well, maybe we can rematch it this way, or we can count it this way that will get a certain outcome. And so it's why in our list of proposed reforms to Article 5, we say that we need clear guidance about how these applications are to be counted. But to answer your question, they can be rescinded, we would argue. Recently, Illinois, for example, rescinded all of them, I believe. They said, we don't want to have anything to do with this. And there have been applications submitted during the progressive era that were still outstanding. Illinois even had an application that was submitted during the Civil War in a failed attempt to use Article 5 to address issues of national union. And I believe New York has done this, but there are still outstanding applications from New York that was submitted in 1789 as part of the original bargain to get the Bill of Rights. And so there are actually arguments that these applications can be used in the current counting. An application from New York from 1789. I mean, in the law, we would say it strains credulity.
It's absolutely, even with the other route, the Equal Rights Amendment, various states rescinded their ratification of the ERA, which was part of the problem. Now, your state resurrected it here. In fact, I believe it's part of the Constitution now because of what you did here in Virginia. But unlike ratification, we generally believe once you've ratified it, you're done. You can't unratify something. I think we both agree on that. But an application, you probably can rescind it.
Just on this counting point, that I think it's something that sometimes people get lost in the math of it, and they think of it as like we call it the chapter's called constitutional mathematics. People think of it as a numbers game. We argue in the book that it actually should be thought of in a much more political lens, because Congress, at the end of the day, is what issues the call. It's a ministerial act, meaning Congress has no discretion as to the matter. If the standard has been met, they must issue the call. Some people debate that. We do believe it's a ministerial duty. But at the end of the day, it's an inherently political action. And if Congress decides to count applications in a certain way, that's their prerogative. And so there's a large void into which counting theories could arise. And that's why it's important to keep an eye on this. And like we say, we end the book where we do thinking about reform, because at the end of the day, this just is not how the Constitution, this is not the process. And a constitutional amendment procedure should not be riddled with all of these uncertainties. It's too dangerous.
I think we have time for one more question, and then you'll be able to purchase a book, and I believe Senator Feingold and Peter Prindeville will stick around to sign your copies if you'd like as well.
Which makes it much more valuable. Automatic increase in your investment.
Clara.
But we met before. I'm Clara. I'm a second year. And I was just curious. So Jefferson at one point argued that he thought the Constitution should be rewritten every generation or every 19 years. So I was just curious about your thoughts on that and whether or not we could be in this position if that actually had come to fruition.
Yeah, as a young man, that was one of our favorite quotes. Is that we understand, as he said, there should be revolution every 20 years, but not necessarily a violent revolution, but it was his. I think he was, compared to some of these other folks, a little less interested in a specific amendment process, but basically looking for a whole sort of regime change every 20 years. Madison and Washington and the others seem to be more interested in this more formal, so-called bloodless revolution process. But Jefferson's sentiments were very much in favor of future generations having their mark on the Constitution. And your generation has almost no way to put a mark on the Constitution. That's not right.
This is why we say that the core aim of the book is to try and rekindle debate about what we call Washington's middle way. You can kind of plot out some of the founding fathers on a spectrum of kind of belief about how frequent change should be. Jefferson would be one extreme, right, 20 years. James Madison would have been on the other extreme. He said that we should go to the motherboard quite rarely. He feared frequent revision. Washington was really in the middle. He said, we might have said this before, I think we began, he said the Constitution was imperfect, but it's binding on all until it's changed by an explicit and authentic act of the people. He believed that the Constitution should be ratified because it could be changed. It should be enforced until that point. But it should be reasonably possible for the people to pursue that kind of reform. And so we're trying to chart a course down that middle way, and hopefully you might join us on that.
I love reading his sentence that reflects what Peter just said and reflects my feelings about how your generation should have an impact. He said, I do not think we are more inspired, have more wisdom, or possess more virtue than those who will come after us. And that is really, yet again, a Virginian. It's incredible, but really a touching way to think about it.
And I would urge you to, if you don't get it now, make sure you read the library copy or copies that we're going to have at the Center for Politics. This will alarm you, and it should alarm you. And you need to know about this. You don't read much about it in the papers. You don't see anything on TV, though I hope this book will change that. But you really need to understand what's going on before it's too late. And that worries me a lot. It really, I think as you get older, you look back and you realize, my God, things are not working out terribly well, and we had better do something about it while we can. And I just want to thank Russ and Peter for, first of all, the terrific book, and then second, of course, for coming to the university, and Kara for moderating a superb discussion. And let's give them all a round of applause.